On July 29, 2023, Sergeant Eric McLean of the Seneca Falls Police Department stopped former law student Christopher Welch for a defective headlight in a Burger King parking lot in Seneca Falls, New York. Sergeant McLean was later joined by Officer Bryce Rumsfeld and Officer Colin Zettelmoyer. The interaction that followed was captured on Sergeant McLean's body camera.
How you doing, sir?
How are you?
Sergeant McLean with the Seneca Falls Police. Pulled you over because you have a headlight out in your vehicle?
You know, I was actually wondering that because it was a little like, you know, it wasn't lit up 100%.
Gotcha, yeah.
Yeah.
Okay, do you have a license on you?
I do, yes sir.
Where are you coming from tonight?
I'm actually just coming from my house to here to get some dinner.
Okay, everything valid on your license?
Oh yeah, absolutely.
Okay, how many alcoholic beverages you had tonight?
No.
Nothing?
No sir.
Okay.
Yeah, I was gonna get that.
Oh, I thought you were handing that to me.
Oh no.
Okay, alright, you have the registration for the vehicle?
You know what? I mean, it's legit. I just don't have it in here.
Okay, is the car registered to you?
I think it's my girlfriend, Jennifer.
Okay. Just want to
it's one or the other.
Okay, just want to turn the car on real fast to see, just to verify the headlight is still off. You just stay in the car, just let you know.
Yeah, no problem.
No, you're good. Just the passenger side one. You just stay in the car for now.
Okay.
Take a look at your license.
I think it's under her name or my name. I can't remember which one it's registered under, but
It looks like it's maybe your wife Sindoni. Is that
yeah,
your
it's my
girlfriend?
woman. Yeah.
Gotcha. Okay.
Yes, sir.
All right, you're all good. You said no alcohol tonight?
No, hell no. I don't drink.
You know, okay. I smell something fruity. What's that? Is that?
I don't know. Probably my Pepsi or something.
Okay. Yeah.
Yeah, I don't know.
You gotta take a look at your eyes real
Absolutely.
quick. Absolutely.
Nope. Go on.
Just looking for impaired drivers.
Oh yeah, I don't take those tests.
You don't?
No.
Why not?
I just don't. I don't take tests, sir.
Okay. Well, I'm asking you. I'm gonna make sure you're okay to drive your vehicle. Right?
Yeah. No, I understand. I don't take tests though.
Okay. Why not?
I just don't. It's no disrespect to you.
No, I am performing an investigation right now
Okay.
to make sure you're okay to drive your vehicle.
Yeah, I won't. I don't take tests, sir.
Why not?
I just don't. I mean,
Okay.
I take. You know, I am a law student for one, and two, I just don't take tests.
All right, sit tight for me, please.
Okay.
Mr. Welch declines to allow Sergeant McLean to look at his eyes with a flashlight, arguing that he does not take sobriety tests. While Section 1194 of the New York Vehicle and Traffic Law, known as New York's so-called implied consent law, requires drivers to submit to breath, blood, urine, or saliva chemical testing when lawfully arrested for DWI, there is no requirement under New York law that a DWI suspect submit to field sobriety testing. However, the Court of Appeals of New York determined in the 1999 case of People versus Berg that the refusal to perform field sobriety tests can be used as evidence against the defendant at trial. Therefore, although Mr. Welch was well within his rights to refuse to participate in field sobriety tests, if he were arrested for DWI, his refusal would be admissible against him in the criminal court proceedings.
So, man, thanks for coming by. So I pulled over for a headlight. I'm smelling some sort of alcoholic beverage. Smells like it's a fruity drink from inside his vehicle. So I could check his eyes in his vehicle to see if he's willing to perform any sort of test. He goes, no, I didn't do tests.
He's not doing any tests?
I want to see if you get the same odor when you go up there.
Okay.
See what you think.
I'm going to go get my flashlight.
Sure. You get that odor too. I observed him with glassy, watery eyes.
Okay.
So he's coming here to get food, but I just want you to see if you get the same clues that I'm getting.
How are we doing tonight, sir? Where are you coming from now?
I don't answer questions.
You don't answer any questions?
No, I'm
Why?
not.
Why is that?
Because he's trying to give me tests and he's accusing me of drinking.
No, I just asked you a question, sir, to perform sobriety
I
test.
understand, sir.
I'm conducting an investigation right now.
I don't drink for number one.
Okay.
And you're asking me if I've been drinking, sir.
Right.
I don't drink.
Okay, I don't know that. I never met you before.
Well,
It's just an investigation to make sure you're safe to drive, all right? That's all it is.
I understand, sir, but
Okay.
I don't answer questions. It's no disrespect, but at all, you know what I'm saying, at all.
I understand, yeah.
Sonic all units hold here for your
I'm
state
coming here to
Sheriff's
get
Department
dinner
out
for my
domestic family.
family. And, you know, no offense, but I feel like you're
All
kind
units
of
hold
coming on a little
No,
strong.
I'm just doing my job, sir.
And just because a vehicle smells fruity,
No, a fruity alcoholic beverage, like I stated to you, sir.
yeah, well,
You also have watery and glassy eyes.
Of
Another,
course,
another,
sir.
another sign of
And
intoxication.
I have sinuses, I have
Okay.
allergies, I also have asthma.
Okay.
as well.
Okay. Does that cause your eyes to get watery
It
and
does,
glassy?
yes, sir, absolutely.
Because I also have asthma.
Absolutely. Sinuses does, yes, sir.
Okay.
But
Alright.
you have no issue. If you're not drinking tonight, there's no issues taking a test.
I don't take tests, sir. I just don't do it. I'm sorry. Do
Okay.
you have a supervisor?
I'm a supervisor on scene.
Do you have a supervisor?
I'm the supervisor working right now.
Okay. Do you have one available?
No, I don't.
Speak
I'm
up?
the supervisor right now, sir, of the shift.
Okay.
I'm asking you to exit to make sure you're okay to drive right now.
I'll exit, sir. I'm not gonna just not obey.
And I appreciate that.
You want me to exit?
I want you to exit to make sure you're okay to drive.
Are you giving me a command?
I'm giving you a lawful order to exit your vehicle
Yes,
to make
sir.
sure you're okay to drive.
Yes,
all right.
sir.
That's all I'm doing.
You want my wallet?
You don't need your wallet or anything.
Again, I'm not taking any tests, sir. So I don't know what you're. You okay to put this in my? Is this okay?
You're nothing on you?
That's
Nothing?
fine.
Mind if I get
No,
you put
sir.
back down for
I
weapons
do
right quick?
mine. Yes, sir. I don't.
Well,
I
it's going to be an
don't-
officer safety check.
I don't comply.
It's just going to be a quick back down for our safety. That's all it is.
If you have to do it,
I'm not going to hold anything.
no,
Okay.
go ahead. If you have to do it, this is embarrassing.
It's not embarrassing.
I
It's for
run
our
a
safety, sir.
business. I run a local business.
I'm not. There's
This
nothing
is-
against you. If you get out of the
this
car,
is-
I just want to make sure this is your wallet. That you put your wallet in. Okay.
I don't answer questions, sir.
I'm just double checking for officer safety.
No.
Officer Rumsfeld frisks Mr. Welch for quote-unquote officer safety, despite Mr. Welch's initial protests. As we have discussed many times before here on ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that a police officer may order the driver out of the vehicle during a lawful traffic stop as a matter of course. The court also determined in that case that officers have the authority to pat down drivers who are ordered out of their vehicles, but only based upon particularized reasonable suspicion that the individual might be armed. In other words, officers do not have blanket authority to frisk everyone stopped for a traffic violation for so-called officer safety. Rather, the officer must point to objective facts, such as visible bulges, movements toward a concealed area, a prior tip about weapons, or extreme nervous behavior that would lead a reasonable officer to fear for their safety. Now, in this situation, as there was no evidence that would suggest that Mr. Welch was armed, a court would likely determine that the officers could not lawfully frisk him. It should be noted that pat-down searches subject to consent are lawful, regardless of whether or not officers have reasonable suspicion, and Mr. Welch appeared to eventually consent to the frisk. However, consent must be freely given, and there was a strong argument that Mr. Welch's so-called consent was coerced, as the officers continued to demand that they frisk him after he refused to give permission.
So, what I'm asking here is if you had any alcoholic beverages tonight. I'm getting clues of
I answered
intoxication.
your question, sir.
I
I
understand
do
that.
not drink. If you're
Okay.
getting any clue of intoxication, you need to go back to school.
I've been a cop for 8 years. I know what signs of
Sir,
intoxication
I'm
are.
being honest with you.
Okay. Well, I never
don't
I
drink.
don't know that. I never
Okay.
met you
Well,
before.
I'm being honest with you.
People have told me a lot of things in the past. All right.
Yep.
So what I want to do is check your eyes to make
I'm
sure you're okay to drive.
absolutely not doing that, sir.
Would you be willing to walk for me?
No, absolutely. Absolutely not.
Okay.
I
Why
can't
is that?
believe that you think
No, if you had nothing to drink tonight, this would show that you had nothing to drink.
Sir, I'm not doing that.
Why is that?
Because I do not. I've been through law school and everything else. I do not comply.
You don't comply with the lawful order?
Sir, I've answered your question.
All right. What I'm giving you is a lawful. I'm giving you an
Sir,
order.
I'm telling you, you're giving me an order to take a test.
I'm advising you to take sobriety tests to make sure you're okay to
Sir,
drive your
I will
vehicle.
not take a test. No
Okay.
disrespect.
We're not trying to disrespect you either.
You are, because
No,
you
no,
keep
sir.
asking me multiple times.
Sir, we have a job to do. Okay. That's all it is. It's no disrespect towards you.
I've answered your question.
We get
sir.
lied to
I will
every
not
day.
take any tests. I will not, and it's no disrespect. I have a lot of friends that's law enforcement. You know what I'm saying? I would not disrespect in that way.
We
Right.
appreciate
It's
that.
just
We're not
I do
disrespecting
not
you either.
take tests. I do not. In fact, I've dealt with you before previously.
Recall when I
I
dealt
was
with
in
you.
Rittmer Lane before you came to my house and asked me a bunch of questions.
Okay.
Also, again.
Oh, was
I
that
felt
about
like,
was that the Uber thing?
Yes, sir.
Okay, I do
Yes,
recall
sir.
you now. Okay.
And I was more than respectful.
I know
to
you were,
was I
and
not?
I appreciate
I'm a
your
little
cooperation.
nervous because here I am at Burger King, getting dinner for my family.
Right.
And I get nervous when I speak to cops because I just
We're just here to do our job. We're not here to.
get it. But you
Not
pulled
for
me
you.
over for a headlight.
That's correct.
Okay.
Yep.
Now you're pushing it.
I'm not pushing you. I'm just doing an investigation.
You're claiming fruity alcohol. You're saying something that smells fruity. So
A fruity alcoholic
there's a million
beverage.
things. I deliver groceries for Walmart, so maybe
Like I
something
also said,
slipped
you have
out,
you
what
have
I'm
watery
saying?
and glassy eyes. That's a
Okay.
sign of intoxication.
Many people have that, sir.
Okay. Well, I don't know. I never.
Just because somebody has glossy eyes doesn't mean anything.
Yes, it's a sign from our training and experience.
Okay.
It's a sign of intoxication.
Okay, well, okay. So what are you going to do with this, sir?
Sit tight, let's just get real fast.
Absolutely. I'm always done.
Sergeant McLean argues that watery or glassy eyes are a sign of intoxication. While there are many other potential causes of watery and glassy eyes, they can be considered a factor suggesting alcohol impairment when combined with other clues suggesting intoxication. However, even when combined with the alleged quote-unquote fruity alcohol smell in the vehicle, it is improbable that a court would find that Sergeant McLean had probable cause to arrest Mr. Welch for DWI, particularly in consideration of the fact that Mr. Welch was stopped for an issue with his headlight and therefore was not exhibiting any impaired driving. As the New York City Criminal Court explained in the 2023 case of New York versus Gilliland, the law recognizes that the average person can consume a certain amount of alcohol without their ability to properly operate a motor vehicle being impaired. Accordingly, the court determined that evidence that simply shows that a person drank some unknown quantity of alcohol and then drove a car does not establish probable cause for an arrest. Rather, for an officer to have probable cause to arrest for DWI, there must be some additional sign that the alcohol consumption has quote-unquote actually impaired the person's physical coordination. As such, the court held that the combined presence of odor of an alcoholic beverage, glassy, bloodshot eyes, and a fatigued demeanor was insufficient to establish probable cause for impairment. Likewise, a court would almost certainly conclude that there was insufficient evidence to arrest Mr. Welch based on his allegedly glassy and watery eyes and the fruity odor in his vehicle.
All right, man. There's no disrespect between me and you. I'm just doing my job.
Yes, sir.
You don't want to perform tests.
No, sir.
Which I understand. You don't have to if you choose not to.
And again, it's no disrespect.
Yeah, no,
it's just that I know my right.
Right. Understood. Understood. So I'm gonna write you a ticket for the headlight. Okay.
Okay.
Do you mind just stepping back in your car for me, please?
Absolutely.
So I can get that going. Just hop back in the front. Hop back in the driver's seat.
I just want to back. It's so weird. 'Cause I just literally replaced that one back late.
Right. Okay.
Shit.
Well, you can do that. You can go home and you can get inside. And you can
Yeah,
sit at home.
it wasn't too long ago.
Okay.
So yeah.
There'll be a fix-it ticket for the headlight, and then
Okay.
you'll have until Monday to get it fixed on.
Till Monday.
Yeah, because it's
Okay.
usually the next business day. But
Now, what do I do with that? Do I bring it
Just-
to the sheriff or not sheriff?
You can go.
to the-
Literally, you can go to any. You can go to a mechanic to sign off on it.
Okay.
A law enforcement officer. There's
You're gonna write me a
instructions.
ticket just for that? For real?
We're doing traffic enforcement tonight.
You cut me out here all this time. You're gonna write me a ticket for that?
Doing traffic enforcement, sir.
All right, buddy. What's your name, sir?
Sergeant McLean.
Do you have a card?
I do have a card. It'll be on the, my name will be on the ticket as well.
All right, sir. I
All right.
appreciate
Just give me a
it.
moment, please.
Thank you. Appreciate you guys.
I was calling to see if we could do a possible obstruction charge for not wanting to provide submit the standard field sobriety test. You can do an obstruction charge.
Kept backing away from me, so I don't.
So did you get? I got a whiff of like a
In-
fruity alcoholic beverage.
in the car.
Yeah, that's the odor I was getting from the vehicle, which is what I explained to him. And then his eyes were glassy and watery.
And then I couldn't, like, he got back and kind of backed
Okay.
away from me when I was trying to talk to him.
Right. Okay.
But he wouldn't, like, I couldn't get a strong
He's
enough.
also steadying himself on the hood of the car. He was talking to us, he kept touching it.
His eyes were glassies.
All right, sir. So you got a citation for inadequate headlight.
Okay.
So, you wanted to speak to a supervisor of mine. So
Okay.
I notified my lieutenant on the phone.
Okay.
He's aware of what's going on.
Perfect. Thank you.
So I can't determine if you're okay to drive or not.
Mm-hmm.
So you refused the sobriety test.
Yes, sir.
I told you have signs from my training experience of intoxication.
Yes, sir.
You have slowed, mumbled speech.
Mhm.
You have watery and glassy eyes.
I know
All
what
right.
you said, sir.
Okay, and I
Yes,
smell
sir.
an odor of an alcoholic beverage emanating from inside the vehicle.
Okay.
So I don't know if
Yes,
you can
sir.
drive or not. So you're gonna have to call someone to pick you up to drive.
Okay.
Understood? So that's what.
Okay. You want me to call someone right now?
That's correct.
What am I gonna do with this vehicle? Leave it here overnight?
I will let them know to stay here.
Sergeant McClain decides that he will require that Mr. Welch have someone drive him home since he did not submit to field sobriety testing. However, a police officer who has finished a DWI stop with no arrest has no legal authority to forbid the driver from driving away in their vehicle, and a court would likely conclude that such an order was an unreasonable seizure of the individual and their property in violation of the Fourth Amendment. Now, while officers do have limited authority to impound or restrain a vehicle in order to protect public safety, under the so-called community caretaking doctrine, the Court of Appeals of New York concluded in the 2024 case of People v. Brown that such police intrusions must be narrowly tailored to address a perceived need for assistance. The court also noted that the community caretaking doctrine cannot be used to circumvent basic Fourth Amendment protections, and that, as with any seizure of a person or property, seizures under the community caretaking doctrine must be reasonable. Accordingly, having resolved the traffic stop and concluded that there was insufficient evidence to arrest Mr. Welch, a court would likely determine that Sergeant McClain's compulsory order that Mr. Welch refrain from driving without any sort of legal process or sufficient evidence to form probable cause exceeded the limits of his authority and was an unconstitutional interference with Mr. Welch's Fourth Amendment rights.
Okay.
Okay.
All right. Yeah, let's do that. Sounds good.
So that's issue your,
All right, sir.
your license.
All right.
You wanted a business card as well, you said?
I do. Yeah.
So
Yeah, I'll grab my phone.
that's fine. Like I said,
That's all right. We can play this game.
I'm not playing any games,
Oh,
sir.
sir, you're being very disrespectful. I will file a complaint.
I've never been disrespectful to
Sir, you are being very
This
disrespectful.
is all recorded on body
We
camera.
have pushed this above over a chat.
I have not, sir.
Okay.
This is all recorded on body camera.
Excellent. I appreciate that.
No problem.
I have it all recorded as well, sir.
That's fine.
I guess that's it then. Yeah,
All
just
right,
give me
I'm
your
gonna
number.
give you. Yep. Here's the contact number.
You have a card?
Here's a citation. You have a court date of August 14th at 12 p.m. in the town of Santa Claus Court.
Yes, sir.
For the correction ticket, you have to get it corrected by Monday
I will. Yes, sir.
and have it signed off by a mechanic or a police officer. Okay.
You got it. Yes, sir.
There's my business card right here, sir.
All
Here's
right.
a citation. Like I said, my lieutenant's been made aware of the
Here,
situation.
Lieutenant. What's his name?
Lieutenant Clear.
Clear. Yes, sir.
He's been made aware of the situation.
Okay.
All right.
Yes, sir.
Any other questions for us, sir?
That's it.
All right. Have a good rest of your night.
After his detention, Mr. Welch filed a pro se lawsuit in New York State Court against Sergeant McClain, Officer Rumsfeld, Officer Zettelmoyer, the Seneca Falls Police Department, and the town of Seneca Falls. As of the date of writing this episode, the case is still pending. Mr. Welch also submitted a FOIA request and obtained Sergeant McClain's personnel records from his time as an officer with the Greece Police Department in Greece, New York. The records include an investigation into a use of force incident that occurred on June 5th, 2020, where Officer McClain deployed his taser for 53 continuous seconds on a citizen who was non-violently resisting handcuffing, without providing him with the opportunity to comply during that time. During that investigation, a statement was obtained from a sergeant who detailed numerous problematic incidents involving then Officer McClain. Most relevant to Mr. Welch's situation, the sergeant reported that in February of 2020, Officer McClain attempted to charge a driver with obstruction for refusing to participate in field sobriety testing. The sergeant explained to Officer McClain that citizens have the right to refuse to perform sobriety tests, and that citizens are not obstructing officers when they exercise their option to refuse the tests. In response, Officer McClain became, and I'm quoting, argumentative and defensive that his charges were justified, and instead of complying with the sergeant's orders to modify the report, he had a lieutenant sign the report instead. The statement also reported an incident from June of 2018 where Officer McClain seized and disposed of legal synthetic supplements that he discovered during a motor vehicle accident investigation. Officer McClain attempted to justify his actions by arguing that he believed the lawfully possessed supplements were causing a driver to behave quote-unquote irrationally. The sergeant also noted that Officer McClain had become progressively more defensive and defiant over the years, refused to take responsibility for his mistakes, jumped the chain of command to avoid abiding by the rules, and continued to ignore department policies that had been explained to him, quote-unquote, to exhaustion. Ultimately, the investigation into the taser incident concluded that Officer McClain violated multiple department policies, including the use of force and taser policies. And on July 13th, 2020, Officer McClain submitted a letter of resignation to the Greece Police Department. I have included a link to the personnel records in the description below if you're interested in learning about these incidents in further detail. Overall, Officer McClain gets an F. Because although he ultimately did not arrest Mr. Welch, he has demonstrated a clear and consistent disregard for the right to refuse sobriety tests. He unlawfully ordered Mr. Welch not to drive and conducted a coerced frisk without reasonable suspicion. Although the traffic stop began lawfully, nearly every decision Sergeant McClain made after that point strayed outside the bounds of his authority. The sergeant has a track record of accusing citizens who refuse to comply with sobriety tests of committing the offense of obstruction, and despite being explicitly told by his superiors at his previous department that he cannot force citizens to take sobriety tests, he still called the superiors of his current department to see if they would allow him to arrest Mr. Welch. It appears that he knew he didn't have enough evidence to justify an arrest and was attempting to create probable cause through coerced compliance. When that approach failed, Sergeant McClain pivoted and ordered Mr. Welch not to drive home. There was no arrest, no citation for impairment, and no proper basis for a seizure of either person or property. His order wasn't supported by law or department policy and had no real safety mechanism behind it. If he truly believed Welch was impaired, he could have followed him, called for a warrant, or escalated the stop through legal means. Instead, he took a shortcut and issued a command that he had no authority to enforce. This interaction is particularly troubling when coupled with what is known about Sergeant McClain's past. The investigator from the taser incident mentioned earlier shared his concerns about the sergeant in his report, stating, and I'm quoting here, "Considering the documented performance history and observations I have made, there is question as to whether or not Officer McClain is fit to perform the duties of police officer, considering the stressful and unpredictable nature of the job requiring quick thinking and sound decision-making. How Sergeant McClain was even hired by the Seneca Falls Police Department after being forced to resign from his previous department is troubling. But the fact that he's working in a supervisory position as a sergeant demands scrutiny. At this point, Sergeant McClain is displaying a pattern of willful ignorance for the constitutional rights of the citizens he interacts with. And I agree with the investigator that he appears to be unfit to perform the duties of law enforcement. Mr. Welch gets an A+ for calmly and effectively asserting his rights, refusing to provide the sergeant with evidence against himself, and for following up this encounter with the proper legal action. Throughout the course of the stop, Mr. Welch demonstrated a clear understanding of his legal rights and asserted them in a measured and non-confrontational manner. His refusal to participate in field sobriety testing was entirely within his rights under New York law, and his decision to do so likely prevented officers from using subjective observations to establish probable cause for an arrest. Field sobriety tests are inherently interpretive, and individuals who agree to perform them under pressure often find themselves facing charges based on ambiguous or marginal indications of impairment. Mr. Welch's refusal effectively removed that possibility from the equation. In addition to declining the tests, Mr. Welch also voiced his objection to being frisked without cause. Although he ultimately complied with the pat-down, the circumstances surrounding his consent raise valid questions about whether it was freely and voluntarily given. His behavior throughout the interaction remained calm, consistent, and non-threatening, which directly contradicted the officer's justification for conducting a search based on safety concerns. Mr. Welch also pursued legal action following the incident by filing a lawsuit and submitting a FOIA request to obtain Sergeant McClain's personnel file. These actions not only reflect a thorough understanding of the mechanisms of accountability available to the public, but also uncovered prior misconduct that placed the sergeant's actions during this stop into a broader context. Mr. Welch's conduct not only exemplifies how citizens can responsibly assert their rights in the face of police misconduct, but it also serves as a rare example of how seeking accountability can expose broader injustice. I commend Mr. Welch for having the courage, conviction, and ability to navigate this encounter effectively, and I wish him the best with his pending lawsuit. I will be sure to include an update to this case in a future update episode. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.